Hi everyone, let's talk about corporations. In this lesson, we'll define corporation and list the major characteristics of corporations. We'll describe the limited liability of shareholders of a corporation. We'll list and describe the classification of corporations. We'll describe the process of incorporating and forming a corporation. We'll describe the powers that a corporation possesses. We'll describe how a corporation is financed, both through equity and through debt. And then finally, we'll describe how a corporation is dissolved and terminated. This chapter continues our small series here on the forms of business ownership. When selecting a form, there are a few major characteristics that people are looking for. Key among those is how liable are the owners and the members for debts and obligations of the business. Do you have personal liability or is it limited? And then also, how is taxation handled? Is it pass-through taxation, or as we'll learn a little bit with corporations, exists what they call double taxation. So those are two of the key things that people are looking for. But you're also looking for things like, how is management done? How easy is it to raise money? How are the profits shared? So these are all things that go into play when looking at what form you want your business to take. So anyway, a corporation is a fictitious legal entity that is created according to statutory requirements. Those requirements will be spelled out in, every state has their own version of what those requirements are. And those requirements can vary fairly widely among the states. And then some states craft their laws to try to attract corporations to form in their state, Delaware being key among those. So shareholders are owners of a corporation. They have voting power, and they can elect the board of directors and then vote on fundamental changes in the corporation. So as you grow up, and some of you may have already be grown up and have been investing for a while, but when you start investing, if you're buying shares of stock in corporations, oftentimes you'll get these letters in, usually by email nowadays, that there's a vote coming up. So all the shareholders get together and vote on whatever key thing that the corporation is considering at the time. And that's your right as a common shareholder. Okay, corporation statutes. So like I said, each state has their own version of statutes that regulate the formation, operation, and dissolution of corporations. I gave you a link to North Carolina's if you want to read through North Carolina's Business Corporation Act. Most of the stuff we'll study in here is sort of generalized to where you get some background information on corporations. Of course, if you're wanting to incorporate in a state, you should really work with an attorney in that state to understand what their rules are and how to do it best in that area. But, a lot of stuff we talk about kind of applies nationwide, hopefully. Okay, the corporation as a legal person. So companies like corporations, LLCs, are considered to be separate legal entities from their owners. The corporation exists as a artificial person in and of itself, whereas you and I would be natural people. The corporation would be an artificial person. Corporations do have the power to sue or be sued. They can enter into and enforce contracts. They can hold title to and transfer property, whether it be real property or personal property. They can also be found civilly and criminally liable for violations of the law. So it exists as an artificial person, meaning it has these rights, the entity itself. So when you hear people say that corporations are people, it's true in a couple of senses. One is it exists as this artificial person. And then the other thing that they probably mean is that the corporations are composed of a lot of people trying to achieve a common goal. So you kind of have to dig into what exactly they're trying to say when they say something like that. Okay, some characteristics of corporations. You have the free transferability of shares. You don't have to have shareholder approval to sell some stock in a company to somebody else. We have the securities markets like the New York Stock Exchange and the NASDAQ. They're developed for the organized sale of these securities. It's incredibly easy. You can set up an online brokerage account and start trading stock within a day or two. So that makes it incredibly easy to transfer your share of ownership in a company, as long as it's not too large. They do have perpetual existence, so there's no need to set a duration on a corporation's existence. It's just kind of assumed that they'll exist in perpetuity as long as the corporation can continue operating. Centralized management, so we vote on a board of directors. Those board of directors, they will appoint your chief operating officer, chief executive officer, the other management team that will handle day-to-day operations, and then the board of directors kind of oversees the management. You also have limited liability as a shareholder. If I buy some stock in Microsoft or Google or Apple, and let's say one of those companies is sued, my personal assets aren't on the line. I might lose some stock value. Even if my stock is zeroed out and it goes down to nothing, all I've done is lost whatever money I invested in that company. They're not going to come after my house or my car or anything like that. Okay, so we mentioned already that corporations have a board of directors. This is the panel of people elected by the shareholders. They make policy decisions concerning the operation of a corporation. For the day-to-day decisions, we have the corporate officers. So think of all the three-letter acronyms, your CEO, COO, CFO, all these people. But they're employees of the corporation who are appointed by the board, and they manage, like I said, the day-to-day operations. And then we already talked about the limited liability of shareholders, but just to reiterate, because this is one of the main characteristics people are looking at is, how liable could I potentially be if the corporation is sued or if it goes into debt and it defaults, So all you're really on the hook for as a shareholder is just, whatever you put into the company. They can't, again, come after your personal assets. Only in very rare cases could, like, even a corporate officer, if they own stock in a company, it's not very common that you would go after even a corporate officer's personal assets unless you can prove that they defrauded somebody or were engaged in some kind of illicit activity. Okay, so just a little graphic. This may or may not be helpful to you to envision what a corporation is, but the basic idea is you have the corporate entity up top in blue, illustrating that we're dealing with all sorts of third parties, customers, suppliers, whoever else it might be. And then you have all the shareholders down here. They provide capital investment into the corporation by buying those shares of stock. Their liability is limited to their capital contribution and don't have any personal liability for the company's debts and obligations. A small illustrative case here, we had a tragic case of a person who was under the age of 21 who was served alcohol at a bar, got in his car, drove away and caused a crash. So the person who was injured sues him. The person who was driving, they also sued the owners of the bar, which was a corporation. A corporation owned a bar among other restaurants, and also personally sued the owner of the corporation, who was Fraioli. So Triumvirate is the corporation. Fraioli is the owner of Triumvirate. O'Neill was the kid who got drunk and caused the crash. So they sued Fraioli in his individual capacity. So everybody was kind of under the general understanding that O'Neill would be liable, but what are the odds that he has very much money? It's not very high. Triumvirate, a corporation, much more likely that they would have money to pay out for liability. And then just in case they weren't successful there, they sued Fraioli as well. And that was the main question, is Fraioli personally liable? And the court decided no. There was no evidence that they could bring to the court saying that they should disregard the entity Triumvirate and go after Fraioli personally. So they were only able to go after O'Neill and Triumvirate. Okay, so we're going to lay out some vocabulary for you when we describe corporations. A lot of different labels we can give them, and many labels can apply at one time. So we'll just give you some of that background vocabulary so you can understand when people are talking in the business world what they're talking about. So for-profit corporations are created, as the name would imply, to conduct business for a profit. We can distribute those profits to shareholders in the form of dividends. We can also reinvest those earnings back into the company. That'll be up to the executives and the board of directors to decide what to do there. For-profit corporations can be public or closely held. That just means a public corporation is sold on those public stock exchanges, New York Stock Exchange, NASDAQ, whatever. A closely held corporation is owned by a small number of shareholders, and they're not publicly traded. Oftentimes what you see is this is like a family business that incorporates, and then the family members are the shareholders. So we're dealing at business at a slightly smaller level there, but that's what closely held means. Okay, so just like I said, publicly held corporations have many shareholders. Their shares are traded on securities markets. They're rarely ever involved in management, but with a closely held, this is also known as privately held. It means the same thing. Closely held, privately held, same thing. Not traded on public exchanges, typically owned by a very few number of shareholders, and they're often also involved in management because the owners are usually handling day-to-day business as well, especially when you think of like a family business. They're not always family businesses, but it's common. Okay, professional corporation is a private corporation formed by professionals like lawyers, accountants, physicians, dentists. We've seen similar forms of business ownership happen with partnerships and LLCs as well, where there's specific rules set out for certain types of professionals like these, like lawyers, accountants, physicians, and dentists. And they can have their own, known as a professional corporation here in this context. You can also have not-for-profit corporations. Not-for-profit, same thing as nonprofit, just different ways of saying the same thing. They're formed to operate for charitable causes, so charitable colleges, charitable universities, charitable hospitals, whatever the charitable cause is. The purpose is not to generate profit. The purpose is more toward providing some sort of charitable service out there in the community. And they can generate a profit. There's rules regarding what they can actually do with that. Yeah, that's the goal being different than a general for-profit corporation. These generally do not have shareholders, and there's specific legislation surrounding nonprofits. So I linked you also to North Carolina's version of the Nonprofit Corporation Act if you ever get interested in reading a little bit more about our rules specifically. All right, a government-owned corporation is one that is formed to meet some specific governmental or political purpose. So there are many of these. The FDIC is the government-owned corporation that ensures our deposit accounts in banks in case the bank was to fail. The U.S. Postal Service, of course, delivers all of our mail. FNMA is Fannie Mae. That's the corporation that handles a lot of home loans, as the government decided that it would be a good idea to try to help individual people be able to own homes. So there are lots of government-owned corporations that meet specific goals established as being important by the government at the time. A domestic corporation is one that is incorporated in that state. If it's incorporated in that state, it's called domestic. And then in every other state, it would be called a foreign corporation. If it's incorporated in another country, it would be called an alien corporation. So domestic in the state where it's incorporated, foreign in every other state, and then alien if it was incorporated in another country. Then we have holding companies. These are also known as conglomerates, but they're basically a company that buys other companies. So we're usually dealing with one company, like maybe Berkshire Hathaway might be a really good example of a company that goes out. They just look for business opportunities. They try to buy other corporations that they think fit within their general model. And then they try to work toward efficiency to try to enrich the shareholders that way. There are lots of them out there. So Alphabet is another example that it used to just be known as Google. And then they decided to reorganize, creating the holding company Alphabet that would then own Google. And then they split off Google's operations into several other bits and pieces that are all owned by Alphabet Inc. Okay, so a little bit about the incorporation procedure. We'll try not to get too much in the weeds. Generally, what's going to happen if you're thinking about incorporating, you can kind of do the paperwork on your own if you go through LegalZoom or something like that. I wouldn't necessarily recommend it. Probably a good idea to work with an attorney who can help make sure that you're doing it correctly from the get-go, especially if you're thinking about growing into a larger business. But just a little bit about the basics. You can only be incorporated in one state. And for the sake of convenience, most corporations choose the state in which the corporation will be doing most of its business. However, a lot of large corporations choose a different state, and it's very common for large corporations to be incorporated in Delaware. The reasoning behind that is Delaware has very business-friendly, corporation-friendly laws regarding the incorporation process and how management works, how liability works, everything like that. So since Delaware has the most business-friendly laws, then a lot of corporations just incorporate there. And then they can do business in any other state. You can still do business in any other state. You're just incorporated in one. I also gave you a link there to North Carolina's incorporation procedure, again, if you're just interested to see how we do it. So you'll want to select a corporate name. So one of the rules is that it has to include certain language, like it must contain either the word corporation, company, incorporated, or limited, or you can also use the abbreviations Corp, Inc., Co., or Ltd. You can't choose a name that's trademarked by another company already. It should be distinguishable from other business names. I can't make it too close to somebody else's business name, especially when they're operating in the same industry as I am. There's a link there to North Carolina's business name search if you're ever just interested in searching through. If you got a cool business idea and you want to just search through and make sure you can use the name you had in mind. This is not a requirement, it's just a good idea. You also want to look and see if that name is available as a domain on the internet. Again, not a legal requirement necessarily, but it could just introduce some complication if you're trying to establish an online presence and somebody else owns the rights to yourbusinessname.com. Okay, so some terminology here. The incorporators are the parties who sign the Articles of Incorporation. The Articles of Incorporation is the document that you're going to send to the Secretary of State's office to form the business organization. A promoter is a person, or it could be multiple people, who organize and start a corporations. And they have the ability to negotiate and enter into contracts in advance of the corporation's formation. They also are typically the ones who are going to find initial investors to try to finance the corporation. So these are just people who are trying to get the thing up and going and off the ground. It's not always a great idea to enter into contracts before we form the corporation, but it can happen, and there are some rules regarding liability for both the promoter and the corporation in that instance. And that's what we mean when we're talking about promoters' contracts. Those are contracts entered into by the promoters on behalf of the proposed corporation before it's actually incorporated. So speaking of liability, we analyze a few scenarios. One scenario is the corporation never comes into existence. Just something goes wrong and we never follow through and complete the incorporation. then the promoters all have joint personal liability on that contract, unless we can somehow get the third party that we contracted with, to exempt the promoters from liability in that instance. Maybe you can get them to agree to it, but why would they? It just really increases the risk on their end. But maybe. We're thinking about things like, you can do all sorts of things. Maybe you're buying supplies. Maybe you're signing a lease for a business office, whatever you're doing. If you're just trying to get going as fast as you can, then these contracts can exist pre-incorporation. A next scenario is that the corporation is formed. Then the corporation would be liable on the promoter's contract only if it agrees to become bound to the contract. So that would be a decision for the board of directors to make, and usually they'll agree to be bound to those contracts because the promoter is going to be heavily involved in the incorporation process. And let's say that the corporation does agree to be bound to the promoter's contract. The promoter still remains liable. And one way for the promoter to remove their own personal liability in that situation is to get the corporation to agree to a novation. And that's a legal term that just means that we're basically just going to form a new contract. So we'd get the third party to say, okay, this guy's no longer liable. Now we have a new contract with just the corporation, and the promoters are no longer personally liable. Okay, the Articles of Incorporation is the basic governing document of the corporation. It's the paperwork we have to file with the Secretary of State's office to exist as a company. It's going to contain some basic information. Then it can get much more detailed than that. But, the name of the corporation, number of shares that are being authorized for sale, the name and address for the registered agent and incorporators. We have to contain a term. If we don't contain a term, it would just be in perpetuity, what the purpose of the organization is, whatever limitations there might be, any regulations of affairs. You don't have to have all those other things in it, but it may contain all those other things. It can be incredibly simplified or it can be incredibly complex, just depending on what we do there. And then a lot of states are opening up e-filing of documents these days just to make it easier to form businesses. There's a very simplified example of what an Articles of Incorporation might be. So, the name of the corporation, what the purpose is, the name and address of the registered agent for the corporation. We'll get into a little bit more about what that is a little bit later. And then how many shares they're issuing, in this case, 1 million shares. And then the names of who the initial directors of the corporation are. So, just some basic information. Okay, so corporate status. So when does the corporation actually come into existence? According to the newer revised Uniform Corporation Act, which we have not adopted yet in North Carolina, it would exist when the Articles of Incorporation are filed. In North Carolina specifically, existence begins when the articles become effective. So there's a little bit of a technical difference there. Instead of just when you file them, it's when they become effective. And once the articles become effective, then we have what we call conclusive proof of the corporation's existence. So that just means that the Secretary of State's filing of the Articles of Incorporation serves as proof that the incorporators have satisfied all the conditions that are required for incorporation, and now we officially exist as a company, as a corporation specifically. Okay, so the corporation can have a stated purpose or not. Most corporations probably just operate under what's known as the General Purpose Clause. This means that the corporation can really engage in any activity that is permitted by law. So you can do almost anything as long as it's not illegal. There are a few other restrictions on it, but that's basically the idea. You could also operate under a Limited Purpose Clause. stipulating the activities that the corporation can engage in. That's a way of it might be required if you're going into certain things, like you're doing like a professional corporation or something like that. Or it could just be that when you incorporate, you want to state specifically what the corporation does so that later on they don't change their mind and start doing other things. A registered agent is a person, or it could also be a corporation, that is empowered to accept service of process on behalf of a corporation. So we have to have somebody to mail legal documents to. So there has to be a person. That person could be a natural person or an artificial person, and there has to be an address that we can send official legal papers to. That's the registered agent. The registered agent may or may not be an actual employee of the corporation. It might just be, a lawyer that's representing the corporation. The office where the documents are being mailed to may or may not actually be a place of business for the corporation. Again, it could just be an attorney's office or really anything. You just have to have an official person named with a place that you can serve these legal documents to in case of like a lawsuit or any other legal action. Okay, corporate bylaws is, when you form a corporation, you get to set your own rules for how you want things to work. And that's, all those rules are codified there in the corporate bylaws. So you get to create your own rules about how our election is going to be handled. What would we do in the event of a hostile takeover attempt? Any kinds of other things you want to establish in the bylaws. So containing things like provisions for managing the business, the affairs of the corporation, how our internal management structure is going to work. We can go back and amend those bylaws, and we can also, in the bylaws, stipulate the process for amending the bylaws. So does it require just a majority vote? Does it require a 2/3 vote? How do you want to handle it? That kind of stuff. All those rules can be set up in the corporate bylaws. And it's important to work, again, I think it's very important to work with an attorney to help you write these things, because they can help you avoid common problems you might not be aware of, just because if you've never owned a corporation before, never operated in this context before, there might just be a lot of things you aren't aware of and problems that could pop up. And if they can help you avoid some of that, that would be great. The book does give you a very small excerpt of what an example of some corporate bylaws might be. That would be much longer than just this one page. There'd be multiple pages, could go into the hundreds of pages for bylaws, just depending on how detailed you get. But again, the basic idea is that you get to set your own rules ahead of time of how you want things to run. Okay, so common to hold an organizational meeting. So at the very beginning of a corporation's existence, we bring together the directors of the corporation, we adopt the bylaws, we elect our officers, the CEO, COO, all those, and then just get started doing business enough to get us going as a company. That would be called the organizational meeting. It's also common for corporations to adopt a corporate seal, some kind of design that contains the name of the corporation as well as the date of the incorporation. And then that seal could be imprinted on certain legal documents, especially if those documents are supposed to be under seal. I don't think a company necessarily has to have a corporate seal, which is very common for them too, as like a cool design choice. The book also gives you an example of what minutes of an organizational meeting might look like. One of the things about a corporation is that with all the advantages that come along with it, there are some disadvantages too. And one of those disadvantages is there's a lot of formalities you have to go through. You have to have these annual meetings. You have to keep minutes of the meetings. You have to keep shareholders updated with what's going on in the company. If you're publicly traded, then you have to go through a lot of scrutiny and accounting transparency type stuff. There's a lot that goes into it. So it's not as easy as like a sole proprietorship or simple partnership or something like that would be. So, it would be required of you to keep minutes of meetings that you have, not just for the organizational meeting, but for any board meetings after that. So if you meet certain qualifications, so I mentioned earlier that one of the detriments that people commonly cite with the corporate form of business is what they call double taxation. What that means is that the corporation does its accounting and its own tax return, and then the corporation pays income tax on the profit that is generated, on the net profit that's generated. Then, if the corporation decides to distribute dividends to shareholders, then the shareholders have to pay tax on the dividends that we receive. So the money generated by the company would be taxed at two levels, one at the corporate level and then one at the personal level once those dividends are distributed. That may or may not be an actual detriment, just depending on your perspective and how taxes are being handled. But that's one of the things that's commonly cited. And an attempt to get around that, to say, well, we'd like a lot of the advantages of the corporate formation, but we'd like to not have to deal with double taxation, then the S Corp opens up the possibility of getting both advantages. So corporate protection from liability, stuff like that, as well as just single taxation or pass-through taxation. But not every corporation is qualified. We would have to demonstrate that the corporation is domestic in that state. It cannot be a member of an affiliated group of corporations. It has to have fewer than 100 shareholders, so that's going to disqualify most large corporations. The shareholders have to be individuals, estates, or certain trusts. Other corporations and partnerships cannot be shareholders. We also need to show that the shareholders are citizens or residents of the United States. Non-resident aliens cannot be shareholders. The corporation cannot have more than one class of stock. We'll get into stock classes a little bit more. That does not necessarily mean that the shareholders all have to have equal voting rights. You just can't have more than one class of stock. So if you meet all those characteristics and qualifications, you can potentially elect to be an S Corp instead of what we would call a C Corp or a normal corporation. Looking a little bit into corporate powers, we mentioned this a little bit previously, but it's just looking at, so since we have this artificial person, this corporation, what powers do they have? Well, the express powers are the powers given to it by United States law. So either the U.S. and state constitutions, federal and state statutes, the articles of incorporation, the bylaws, and whatever other resolutions the board passes. What this generally means is just giving us the right to operate as a business. So being able to buy, own, and lease property, to sue other people or corporations, to be sued by people or other corporations, to borrow and lend money, to make contracts, and bind other people to contracts, for ourselves to be bound to contracts. These are all the things that you need to do in order to do business. And these are powers expressly given to corporations. Implied powers are the things that would still be legal for me to do and still be necessary to just go out and accomplish our corporate purpose, but that aren't expressly stated somewhere. It's just implied that we have the ability to do this. And then if a corporation is going beyond what its express or implied powers are, we would call that an ultra vires act. Not that common to hear about that kind of thing happening, but just some terminology for you. All right, so switching gears just a little bit, starting to look at financing the corporation now. We can make this simple or as complicated as we want to. The basic idea is that companies have two major ways of raising money. One is through equity, the other one is through debt. Equity financing means we're giving up ownership of the company by selling that ownership in the form of stock. Debt financing, meaning that we're selling bonds or taking out loans from banks or whoever will loan us money. Neither way is right or wrong. They accomplish similar purposes, but have different pros and cons to them. So we'll look at a little bit at both. So first, looking at equity securities. Equity securities are commonly known as just stock. It's a representation of ownership rights to a corporation. So if I buy a share of Apple, I own a very, 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 very small sliver of ownership in that corporation. When we're thinking about stocks, we're generally thinking about what's known as common stock. So this is the type of stock that is most commonly bought and sold on the stock markets. So it's a type of equity security that represents the residual value of a corporation. It has no preferences. What that means is that stockholders are usually last in line for payments. If the company goes bankrupt and we have to distribute assets at the very end, stockholders are the last in line. When it comes to distributing dividends, they're going to pay preferred shareholders before they pay common shareholders. So that's why stocks are considered to be risky. At least especially common stock are considered to be some of the most risky types of investments because you're last in line. It does not have to have a fixed maturity date. You can issue common stock in different classes. Those different classes can come with different characteristics. One of those characteristics can be voting rights. For instance, very commonly or very famously, Facebook organized itself giving two basic classes of common stock. One has 10 times the voting rights as the other class of voting or the other class of stock. And so Mark Zuckerberg reserved for himself enough of that preferred voting rights class of shares that he still controls personally about 60% of the voting rights to Facebook. So he has complete control of Facebook, the corporation, since he has the majority of voting rights. And then the other class of stock, that you and I can go buy, has still voting rights, but nowhere near the majority, even if we all agreed. So we just kind of agree that Zuckerberg is going to make all the decisions, and we just, hitch our wagon to that guy and hope he makes the right calls. Also, common stock, you can have dividend payments that can be made. It's not required. Sometimes common stockholders will expect it, but it's never 100% guaranteed. If you got really mad as common shareholders, you could try to vote certain board members in or out because you think they'll, be more likely to pay you dividends. But it's the kind of thing that can happen, but it's not guaranteed. And common stockholders do have limited liability. So I stand to lose only the money that I invested in this stock, and they're not going to come after my personal assets. So we differentiate that common stock from what we call preferred stock. Preferred stock operates more like a bond in that there's more or less guaranteed dividend payments, but you don't have voting rights generally. So type of equity security that's given certain preferences and rights over common stock. So a preferred stockholder is a person who owns preferred stock. A different dividend preference means that you have the right to receive a fixed dividend at certain stipulated periods throughout the year. So that, like I said, that operates more like a bond in that you're usually not going for capital appreciation, usually just going for those dividend payments as regular income. You also have a liquidation preference, meaning you have the right to be paid a stated dollar amount if a corporation is dissolved and liquidated. So a little bit less risky, the preferred stock. You're probably not you don't have the unlimited cap on how much you can make because you won't have as much capital appreciation. In other words, the stock price won't go up and down that much. But you're ahead of common shareholders in line for dividends. You're ahead of them in line if the company goes bankrupt and gets dissolved. Assets will be sold and then distributed to people. So you're in line at least above the common stockholders. They also have a cumulative dividend right, meaning that if the stock is designated as being cumulative preferred stock, if the company misses a dividend payment, then you're first in line for those arrearages later. The arrearage is just the missed dividend payments that are still owed to the preferred shareholders. However, if your preferred stock is designated as non-cumulative, then you don't have this right. When it comes to the right to participate in profits, the stock can be designated as either participating or non-participating. So for participating preferred stock, it allows a preferred stockholder to participate in the profits of the corporation along with common stockholders. That just means that there's a potential for a preferred shareholder in a participating preferred stock to get additional dividends beyond what's stated to be distributed. However, the most common kind is non-participating, which means you don't have this right. All this to say, and we're looking at all these different characteristics of preferred stock here, you just have to understand what you're buying when you buy it so you understand what rights you have. Some preferred stock has conversion rights. So for a convertible preferred stock, you have the right to convert those preferred shares over into common shares. Whether or not that's a smart decision just kind of depends, but at least it has this ability to be converted into common stock. However, if the preferred stock is designated as non-convertible, then you don't have that right anymore. And that is the more common form, is the non-convertible. They can also have redemption rights. If a stock is known as redeemable or callable, this can go for bonds as well, but it allows the corporation the ability to exercise its choice to buy back that preferred stock from you at some future date. And you wouldn't have a choice if they decided to call it in, and then they would just buy it from you, and then it's no longer yours, but you got paid for it. Either you're happy with the price or you aren't, but they exercised their right, and there's really nothing you can do about it. The more common form is non-redeemable, meaning the company does not have that right to redeem or call in those shares. The deciding factors there being just people in the company getting together and trying to decide what is in the best interest of the company at the time. If you're interested in investing, there's so much you can learn about common stock, preferred stock, bonds, the different types of bonds out there. It's really fun and engaging and interesting. So if you're interested in that kind of thing, then go out and learn as much as you can. I would avoid jumping into the stock market and doing a bunch of risky investments until you at least understand a little bit. Okay, so moving on with our modern digital age here. It's super easy, like I said earlier, for you to go online, open up a brokerage account, and you can just start trading stocks and bonds right away. Gamble as much as you want to, or you can be super lucky and make a ton of money. It just all depends. But it used to be common back in the day for when I bought stock in a company, I would probably do it over the phone with a stockbroker. And then the company would mail me paper stock certificates representing my ownership in that company. And that really just doesn't happen anymore because pretty much all of the registration of stock ownership is done online. When I buy stock, it's registered in a database somewhere that Jeremy owns X number of shares of this company, so the company knows who all their shareholders are. Okay, so thinking about a little bit more vocabulary describing the types of shares that can exist. So when we talk about authorized shares, these are the number of shares that are authorized in the corporation's articles of incorporation. So if we say there will be 10 million shares that are being authorized, and then we just sell those shares out on the public, then these are the authorized shares. When I sell them, then they're known as issued. So these are the shares that I have sold. They're now issued. They're out there being owned by the public. The unissued shares are the ones that have been authorized, but either have not been sold yet, or maybe we repurchased some shares and haven't reissued them. Those are known as unissued shares. Treasury shares are shares that have been repurchased by the corporation. They no longer have voting rights to them. We could decide to reissue them later on, then they would have those voting rights again. But stock repurchases are a very common thing to do when a company earns money. You can do a few things with that money. You can distribute it to your shareholders as dividends. You can reinvest it into the company, or you can repurchase shares. That's one way of trying to boost your shareholder value. When I reduce the number of shares that are out there, it increases the value of the remaining shares. And so we see that happen all the time. Whether it's good for the company or society in general, just is kind of up for debate and depends on the circumstances. And then finally, we say outstanding shares are the shares that have been issued minus the shares that are in what we would call treasury shares. And these are the outstanding shares, all the shares that are out there being owned by people. So that's equity financing. Now we'll look at debt financing. Just to sort of refocus us here, we're talking about ways of financing the company. So how do you raise money? The two major ways of raising money. So one is through equity, means you're selling shares of ownership in the company. That's fine because I don't have to repay that like I would with debt, but I'm also giving up ownership. So okay, that reduces my voting rights, my control of the company as an owner. Or we can turn to debt. Okay, so now I'm not giving up ownership anymore, but we're taking on debt, which means that I have to repay it. So pros and cons either way, which is best for you will just depend on your own circumstances. So these debt securities are securities that establish a debtor-creditor relationship. The corporation is borrowing money from investors to whom a debt security is being issued. The corporation does promise to pay interest on the amount, and at the end of the instrument's life, you would repay the principal as well. And the maturity dates can vary from months to a period of years, just depending on which type of debt instrument we're issuing. So speaking of those different types, here are a few. A debenture is a very long-term unsecured debt instrument. Okay, so keywords there being long-term and unsecured. This is for a period of years rather than months, and it's unsecured. I'm saying unsecured a lot because that's the key differentiator between debenture and bonds. Bonds are also long-term, but they're secured by some form of collateral. So all that means is if the company goes bankrupt and if we're liquidating, then bond holders, since they're secured, would be in line before debenture holders, since that debt is unsecured. And then finally, we have notes, which are shorter term debt instruments, maturity of 5 years or less. And those notes can be either unsecured or secured, depending on the terms of the note. An indenture agreement is a contract between the corporation and the debt holder that contains the terms of whatever that debt security are. So terms like we have to have the maturity date, which is when does the when does the term end. So it could be like a 5-year bond. And if we're making coupon payments, that would be interest payments every quarter. Then I get an interest payment every quarter, every 3 months. And at the end of the 5-year term, then I get the principal back. So that's the benefit of lending money, is I get interest payments in addition to my principal back at the end of the term, the maturity date. So maturity date, the required interest payment, usually stated as a percentage. If there's any collateral that's securing this debt, if there are any rights to conversion, if there are any call provisions, whatever restrictions might be there for a company to incur additional debt, and then what are my rights upon default. If the company defaults, what rights do I have as a debt holder? And just whatever other terms there are would all be contained in the indenture agreement. So that's equity and debt financing. We're going to wrap up the chapter with just a little bit on dissolution of a company. So now we're looking at the end of a corporation's life. So what are the things that can end a corporation's life? Well, it can be voluntary, it can be involuntary, depending on what's happening. If we just decide we're done and we want to stop doing business and we don't want to sell it and we just want to dissolve the thing and move on with our lives, then that's voluntary dissolution. However, if I'm getting behind on my bills and my creditors are coming for me, that's the kind of thing that could result in involuntary dissolution, as well as getting into legal trouble or not maintaining my paperwork and not observing the corporate formalities like I'm supposed to be doing. But yeah, just first up, voluntary dissolution is dissolution of a company that has begun business or issued shares upon the recommendation of the board of directors and a majority vote of the shares entitled to vote. So we have to have a majority vote of the shareholders and the recommendation of the board of directors, and we can voluntarily decide to dissolve that corporation. We would then file some articles of dissolution with the Secretary of State. We could have an administrative dissolution, which is when the Secretary of State will administratively, this is a form of involuntary dissolution, will administratively dissolve the corporation if it is, now we're talking about disregarding those corporate formalities and other things. So if I'm not filing my annual reports like I'm supposed to be doing, if I'm not maintaining my registered agent like I'm supposed to be doing, if I haven't filed for a change, if the agent changed, if I didn't pay my franchise fee to the state, or if the duration, if I stated a duration, if that duration expires, then we could have an administrative dissolution. It's not super common for that to happen. It's not gonna hit you out of the blue. They're gonna notify you if you're not doing something you're supposed to be doing, and they'll give you a chance to fix it and continue operating as a business. They don't really like to just administratively dissolve companies if they can avoid it. And the last form here that we'll speak about is a judicial dissolution. This is dissolution of a corporation through court proceeding. Okay, so that means that a court has found something wrong going on, and they're going to order that the company be dissolved. Okay, so if they find out that that we procured our articles of corporation through fraud, or if they find that somehow in our operations we exceeded or abused our authority, we could have a court decision where they decree that we dissolve as a company. Again, this is not really that common. It can happen. If they find that a company has really just been up to no good and just flouting the law, then it is possible. And it does happen. It's just not really that common. Okay, so if we say that a company has, we're going to dissolve a company, we have to wind up operations. This means the same thing here really as it does with the other forms of business when we're winding them up. We're just, all right, well, what are all the assets that we have? Let's liquidate all those assets, and then we have to distribute them to whoever we owe money to, and then there will be a priority list of people who get paid before other people. So we're generally looking at like secured creditors getting paid first, and then it just kind of depends. It might be that preferred shareholders get paid, and then all the other unsecured creditors, and then finally common shareholders would be at the very end of the line. It would be very uncommon for there to be any money left for common shareholders after the winding up operation. You know, you're usually not talking about very successful companies that are being wound up. We wrap up just by reiterating what we've said a couple of times. If you look into any big corporation, the big name brand corporations that we're all used to hearing about, it'd be very common if we looked into the details of how they're organized, very common to find out that they're incorporated in Delaware. The statistic we see here is that more than 50% of the publicly traded corporations, so those corporations that are being publicly traded on the New York Stock Exchange, NASDAQ, whatever, incorporated in Delaware. Why? Because that state branded itself as being a very corporation-friendly state. They made their laws that way. So there are a lot of advantages to that. It's more likely for you to win lawsuits. It's easier for you to form. The rules are way more fleshed out, so it's easier to understand what the rules are going to be. So there's a lot of advantages to that. Whether or not it's a good thing for society in general, I don't know. It's up to opinion. It seems to be something we're comfortable with, at least to the point that nobody's doing anything about it. And it seems to be just okay. So just something to be aware of. Nothing necessarily nefarious or illegal going on. It's just very common business practice in the United States to find out that they're incorporated in Delaware. That wraps up this lesson. If you have questions, let me know. Otherwise, have a great day.